Dear colleagues and students, hello everyone. First of all, I want to thank you all for your attendance to our workshop, Critical Approaches to Legal Research. As you all know, humanity is fighting against the COVID-19 pandemic for more than a year. The pandemic leads us to adapt in new circumstances. We have been swapped our education system to the online system since the spring semester of the 2019-2020 academic year. However, we haven't been able to hold any conference since then. At this point, we have offered to Professor Nergis Canefe to do a workshop for the postgraduate and the PhD students regarding their thesis procedure. Thanks to Professor, she informed us that she will be very happy to do so. Before we moving on, I would like to introduce her to you. Professor Canefe is a Turkish-Canadian scholar of public international law, comparative politics, forced migration studies, and critical human rights. She has held posts in several European and Turkish universities and is a faculty member at York University in Canada since 2003. She regularly serves at the executive boards of several international organizations, including International Association of Forced Migration Studies, and is the coordinator of Journal of Conflict Transformation and Security. She is a frequent public speaker on the issues related to the human rights, minority rights, and historical injustice. She penned close to 100 scholarly articles and several books. Her most recent book is The Limits of Universal Jurisdiction, a critical debate on crimes against humanity, to be followed by a volume on unorthodox minorities in the Middle East and comparative politics of administrative law in the Middle East. Professor Canefe is also a trained artist, and her designs and murals have been showcased regularly since 2008. Professor Canefe will take the stage in a minute, but before that, I want to give a say to my colleague and the lecturer of seminar class, Assistant Professor Özlem Can Beltek.
Thank you very much, Nabi Hocam. And I would like to warmly welcome all of the participants, and thank you very much for watching us today. As Nabi Hocam already introduced, we have Nergis Hoca in today's workshop. And I know that majority of the participants are either writing their thesis or they will be writing their thesis soon, either LLM or PhD. And I believe that this is going to be a great opportunity for them to start their thesis. So please take this as an opportunity. So thank you very much, Nergis Hocam. I think now the floor is yours.
Thank you. It's a great pleasure to be here. And I hope some of the discussion that I will share with you will have productive effects on your MA and PhD thesis writing strategies and the process itself. The entire experience of COVID has not been easy for our students especially, because academia requires guidance and interaction and engagement, and those, for reasons that are beyond our control, have not been readily available or available only in a limited capacity. And this has been particularly difficult for students who are actually in the writing stage. So I hope today's discussion and some of the collaboration that we can establish will help you pick up speed again and perhaps focus further in your writing work and creation of academic work. So to start with, I want to tell you that I had the privilege of working with many graduate students over the last 25 years. And there are certain truths that each academic establishes for themselves in terms of providing guidance. So what I'm going to share with you is not written in stone, but some things that I know that works with me and my graduate students. I've also taught courses, PhD seminars and SJD seminars on thesis writing and proposal writing and grant writing. Most of these are year-long, and some of these are actually method courses. So they're not just about the format and how you structure the work, but also about the larger questions that you ask in especially legal scholarship. So what I will be sharing today will be built on experience in different institutions, working with different student bodies, and yet from my point of view, we've seen fairly good results, and some of the techniques and approaches that I'll share with you bring clarity to your research project as you proceed through the stages. So there are about 6 or 7 subheadings, and I would really encourage you to take notes if you can. Although this is a YouTube recorded seminar, and then no doubt you can go back to it, but the old-fashioned pen and paper, and then just taking notes would be to your benefit. Partially also because I'll be asking questions directly to people whose list I have and who are writing their LLM and PhD SJD at the moment. One of the first questions that one has to keep in mind when writing an academic project, either at the LLM level or the PhD level, SJD level, in legal scholarship, is why does it matter? And if you are lucky enough to get to the stage of defense, especially for the PhD SJD, you will be asked that question in the defense. That is to say, your findings, your work is not capable of speaking on its own. You have to engage your audience, and you also have to identify your audience, and you have to identify what's called your intellectual community. And on its own, law does not speak. On its own, history does not speak. On its own, a PhD, an SJD thesis or an LLM thesis does not carry weight in the world. There are many hundreds and thousands which basically perish in the files of graduate programs and do not see the light of the day. So one of the personal and institutional aims that I envisage is very, very important for you and for us as your supervisors, is that your work should see the light of day at the end of your research. And for that to happen, you need to know why you're writing it. I've looked at some of the titles of the LLM and PhD SJD theses that are being undertaken at Near East University Faculty of Law, and they look wonderful. But for the most part, and I know everybody's in their initial stages, they look like topic suggestions. There's only 1 or 2 where I can actually understand why the student is writing them. Rather, they define an area within which the thesis and the work will be written, but I have no clue why, to what end, and what might be the direction that the author is taking in their research. So it's very, very important for you to identify for yourself what motivates you to write this particular piece of academic work. And the second very important piece of the puzzle that is related to the first one is, who's your targeted audience? If you're writing for your supervisor, although it might sound like a logical step and beneficial for your academic career at the time, it is a big mistake. You're not writing for your supervisor. You're writing with your supervisor. You're writing under the guidance of your supervisor, but you're not writing for your supervisor. You actually have to identify a community within which you engage in debates, you contribute, you make a contribution. Now, the expectation in terms of degrees of contribution changes from LLM to PhD, SJD. That's normal. However, even at the LLM level, the understanding is that the debate is not only learned, but it presents a unique angle on an issue. And that unique angle although it is determined by your supervisor in terms of the validity of the approach that you take, you are not writing to your supervisor or you're not writing for your jury. Those are the people who are in a position to train you and to teach you what is considered as solid academic work and legal work. And they are to guide you in terms of showing you the literature and the critical approaches and the craft and vocation of writing academically. But they are not your sole audience. They are the jury. So think of almost like a courtroom. In effect, it's a public occasion. Writing is a public occasion, a public vocation that comes with a lot of responsibility. So it's really important for you to imagine an audience before you actually start formulating and writing your thesis. So who could that audience be? I saw a number of titles that are related to Iraq in the currently registered students who are doing LLM or PhD SJD. So, for instance, my question is, and you can enter those answers in the chat if you wish. Who's your audience? Those of you who are writing on Iraq, I believe there is one on Iraqi refugees in North America. There's another one on WTO and Iraqi property rights and access to WTO, which is very global South take on international law, which I really admire. And then there are a few others. There's one LLM thesis on natural resources in Iraq, legal analysis of Iraqi oil contracts. And I want to ask these students, not only them, but just because they actually identify a particular jurisprudence. Who's your audience? Are you writing for Iraqi jurists? Are you writing for Iraqi public? Are you writing for Iraqi legal academia? But even if it's for legal academia, what part of the debate you want to enter? Are you writing, because you're writing in English, are you writing for Anglo-American academia so that they're informed by the developments and potential problems within the current Iraqi regime, constitutional and otherwise? Are you writing for a particular political group, such as Scholars from the Global South, which I, very honorably take part of? This is the TWAIL approach, Total Approaches to International Law. Are you writing for that audience, for them to consider the Iraqi case? Are you writing for higher courts with the hope that in the long run, your work could be used as part of amicus curiae, or would it be part of the opinio juris? These are your aspirations? Are you writing to work with an NGO later on who looks at investment portfolios in Iraq? I mean, you don't have to write for one audience, but it's really important to pitch your voice, academic voice, with clarity. Because with any form of presentation and communication, if you're not clearly targeting your audience, your voice will come forward as muddled. And you might ask, how do you hear my voice? Oh, your writing is transparent. Writing is the clearest form of expression that also has the highest volume of circulation. So you do have a voice. And most often, we find that our students are very hesitant developing their own voice, their own form of expression, and they imitate and emulate published material with the fear that if they don't do so, they're not going to come forward as learned and erudite. That's one of the biggest mistakes, because one of the things that I emphasize in my training of graduate students is that not the first year, maybe not the second year, but by the time it comes to third year, I want to be able to read a blind copy of your work, meaning, no name, no title at the beginning. And I want to be able to recognize, that's so-and-so. Because there's a form of expression and there's a form of engagement and there's a kind of literature and form of questioning that is unique to each one of us. If we advance enough in our learning, that voice becomes clear. If we're muddled in our undertaking, if we are afraid of coming forward with clarity, and if you're not clear of our audience, that voice never develops, and your work becomes unidentifiable. It becomes yet another SJD on such and such, legal regime of such and such. It becomes a document. So you don't want to produce a document that is voiceless and then that doesn't carry the stamp of your personal engagement. And by that, I don't mean political personal engagement, but academic, scholarly investment and personal engagement on the issue. And this kind of voice you acquire over the years. The LLM and SJD are the first steps of acquiring this kind of strength of voice. And it develops and matures over the years. So one other expectation that sometimes, especially our SGD students have, is they want to write the big work, like the big American novel. They want to write the final word on the subject. And I think that is the courage that comes with youth sometimes, and I don't want to discourage. There's very unique and very important contributions made to the field at the level of SJD. However, the nature of this business of learning and sharing your learning is that it takes time, and it takes experience, and it takes further and further exposure. So likely, and it does happen often, what you found out at the level of PhD, you might change your mind about some of your findings in 10 years' time when you engage with further debate, when you teach. And teaching is a great way of learning, by the way, because as you teach, you learn further and deeper, and you encounter counter opinions. And you have to prepare yourself to defend those opinions of yours or reshape them. So as your product, so to speak, engages with the public, either through presentations as in the form of writing a book and articles or teaching in classes, you will find yourself that you will change some of your opinions. So what you're writing in your thesis is never the last word. It's the beginning of a conversation for yourself and for others on your chosen subject area. Does that mean you cannot provide definitive answers? Does that mean you can get away with not a clear structure? No, it doesn't mean any of those, but it does mean that it is very unlikely at the SJD level, and definitely not at the LLM level, you're going to have a final say on anything. You will in fact come up with more questions than answers. And I'm going to touch upon that when I'm discussing thesis proposal structure and then the common mistakes that we make. Are there any questions thus far? I can just look at the comments before I go further. I don't see anything. And if our moderators could help me, if if there are, and I see some comments here. Omar says targeting the government and legislators, which is wonderful. And I think that's the only person who actually identifies an audience. So I want especially the PhD students, but also the LLM students, to think about what audience primarily they're targeting. And let me repeat again, you're not writing for your supervisors. You're writing with your supervisors under their guidance, but this journey is your journey. Just like the topic that you choose is primarily yours, although the shaping and then the maturing and then the workings of the topic will be determined and aided by your supervisory committee, right? So the next one is, going back to the why should it matter question. As I said, when I looked at the titles that were submitted to me, and I understand these are working titles, other than one or two, I saw topic areas, but I didn't see anything that would make me pick up that book from the shelf if it became a book or a report. It was just like cataloging information. And I think in legal scholarship, it is really, really important that there are more traps in legal scholarship that leads us to write in a way that just documents and that doesn't make an argument, and that doesn't go further in depth. And there is general belief that law itself is such a higher level of discourse. Just by virtue of identifying what laws work and what's the legal framework, we've done our job. And I want to ascertain you can do that, certainly, and then there'll be law schools where that will be all right and acceptable. But that kind of work will have no circulation outside of your own university, and maybe one or two departments of government where you're employed. One of the important things for you is to identify what angle, what vantage point, what theoretical framework that you'll be using. And I know people are very concerned about publishing their work and then making sure it has recognition. But think of it this way: it's a marketplace of ideas. If you're just bringing to the market run-of-the-mill, cheaply made goods, and you want the biggest stands for them to be displayed, surely you could perhaps get a very visible stands to display your goods. But do you think your customers will come back once they look at it and try it and it just breaks and it's not solid and there's nothing substantive about it? Do you think they will actually come back and then revisit your stand? So this business of publishing in the best places, having visibility, first you have to do your own homework. Do you have something to say? Do you have something to say other than defining something or writing intricate legal treaties about what the legal framework is? Are you an NGO? Are you a hired consultant? Or are you an academic? There's a big difference in terms of doing legal research between those two boxes of engagement, right? And in order to make your stance and in order to really earn your salt as a scholar, you have to have some questions to ask and seek answers to these questions. And in order to do that, you really need to establish a theoretical framework from which you're talking about. So what is this big business of theoretical framework? I mean, looking at the titles again, it's very important, for instance, if you're talking about WTO, all right? WTO has an organizational definition. WTO has a legal framework within which it operates. WTO has treaty structures with countries that are engaged with WTO. But are you going to do just fact-finding? And that's called doctrinal research. And there's nothing wrong with that, but that's fit for a report. It's not fit for academic work. That's very limited. And unfortunately, the more the how shall we say, the more the university or the institution embellishes and endorses this kind of fact-finding, strictly doctrinal work, the less that institution itself has credibility and respectability in the wider academic world, because they are not making any contribution. Anybody who has some legal training can put these documents together and then create a portfolio that releases legislation and treaty structures. That is not why you're taking all these courses, and that's not why you're going through the training. So why are you doing this? Because you need to bring in, just like in higher court judgments and Supreme Court judgments, if you receive these decisions and then you look at the the explanation, the statement, the reasoning, you have to bring in a perspective, an interpretation. You have to add to the existing knowledge bases rather than just amassing documents, legal or otherwise, and presenting them in the form of thesis. How could you do that? So I'm going to go back to another one, for instance. There's one here that says asset recovery. I know it's just a topic, and please don't take these as criticism. But asset recovery, where, when, why is that an issue? Describing asset recovery and legal structure is simply documenting. It's not academic work. It could be done by anybody. So I'm not suggesting, the person who suggested it will just do that, but they have to qualify their take on asset recovery. Problems concerning asset recovery in such and such context from the perspective of, then it becomes an LLM. Then it becomes academic work. Another one, Ömer Salah, that legal status of the foreign investor in developing countries. Now, that's a wonderful topic, but it will take about 10 years to complete. That's a very common mistake we all make, and then that's very normal. We keep it so large. Developing countries, 2/3 of the world, legal state of foreign investor, from the eyes of the foreign investor, from the eyes of the government, from the eyes of the WTO, World Bank, which, why, when. All of these questions should always follow you. And as I said, I'm not criticizing at all. I'm not in a position. I haven't met you. I haven't looked at your proposals. I'm simply trying to give examples in terms of how you clarify what you're doing and how you identify a perspective and an angle from which you can then build a debate. So one of the standard exercises that I do in my classes is, let's play a game of naming your thesis. All right. And I tell my graduate students, come up with at least 3 titles for your thesis, LLM or SJD, and if possible, 5. And they shouldn't be the same. They should be looking at the same thing, but tell me 3 or 5 different ways of looking at that thing. And then I share them with members of the class. And I don't allow the person who is writing the thesis to explain. I ask members of the class to tell us what they think the thesis is going to be about. And the more detailed and substantive the title is, the closer the guess is. The more generic the title is, the sky's the limit. Everybody interprets it differently. And sometimes it becomes very, very painfully funny, actually, because, you look at the title, you interpret it according to your background and your theoretical inspiration, and then you come up with a thesis that the writer had no intention of writing. So the first step is be very, very precise, but also detailed and substantive about your title. So it's in the later stages, not now. I know most of you are just at the beginning stage, and I'm going to repeat what I suggested. These are not criticisms. I'm here to provide you training and background, so take it as such. Take it as you're taking part in a game, all right? So if you take it so lightly, then it'll be much easier. And then just let go, and don't feel that you're you're in any way criticized, or you're in any way identified as having deficits. But it's more like, what can we do with this, right? That playful spirit is really important. So one of the things you need to do is play out with a few titles. And if your title is too generic, no one will know what you're writing about. If your title is too specific, there's also the danger of not understanding where you're coming from, your perspective, your theoretical background. So for instance, the last 2 books that I wrote, I keep adding this thing, critical perspectives from the global south. All right. And I'm already telling the leader, don't think I'm writing on crimes against humanity from a generic international or global north perspective. I'm writing from the global south. And what does that mean? Because there's a whole body of literature that I rely on. These are my interlocutors. These are my colleagues. These are my, what I call alibis, some dead, some alive. They don't have to be alive. You don't have to know them personally. But the debates and the questions that they present are important for you. And then that establishes your standing, which then creates the opportunity to bring in genuine interpretation to the legal data that you will amass. And you need that. And we had many decades of a similar debate. History and legal studies are very similar in so many respects, because there's an understanding that in history, facts will speak for themselves. Facts don't speak for themselves. And the way you amass facts, as we know from history from the ground and oral history and alternative history traditions, really determine whose voices you hear. It's the same with legal scholarship. Law on its own will not speak for itself. You will be the voice. And similarly, what you choose to look at will determine the presentation and the perspective of what you're studying. So in that sense, if we start with establishing a title and play with it, really play with it, okay? Try one, try another, make your friends, your family, especially elder people in the family. And this is very important. Academia has long suffered, more so legal academia, from cutting ties with real life. But imagine that law is for everybody. Law is not just for jurists and legal scholars. Law is for the whole society. So if you cannot explain what you're writing about to your 80-year-old grandfather who has seen a lot and who has a whole world of experience of living, and mostly in most difficult political circumstances, because I believe you're all coming from the Middle East. This is not the easiest regions, one of the easiest regions in the world, right? So if you cannot tell it to someone who lived almost a century what you're doing and why you're doing, that's not good news. I mean, I might be able to understand what you're writing on, or Nabi Hoja or Urzum Hoja or your external might understand. But at the end of the day, you should be able to explain it to yourself and to the larger public also in plain words. Why are you doing this? What are you doing exactly? And then that should feed back into your title. So try to run your title with someone who's not legally trained and see how they look at you. And if you can explain it successfully, that's okay. But if you're just like, oh, you don't understand, big mistake. Because law should be translatable, or legal scholarship should be translatable to public information. And that's also the very basic tenets of public law, especially administrative law, right? If it's not understandable, if it's not decipherable, if it makes no sense to even the most erudite person who doesn't have your training, then you're actually establishing a fortress of legal scholarship that is inaccessible and that is not explainable to anybody, and you don't want to do that. So do try different titles, and bear in mind that some of these should resonate with the general public, as long as they have the interest and engagement with your issue. So in terms of what do you do after determining a tentative title? By the way, the title can change. I mean, at the beginning, it's just a topic. Further down the road, as you determine your supervisor, it becomes more like a title. When you do your qualifying examinations and start writing your dissertation proposal, with chapter subheadings and content and bibliography, then it becomes a lot more like a title. But then it can still change when you actually start the writing process, because writing itself has its own journey. And it can take you to places that you didn't envisage that you were going to go. And it happens to the best of us. It's not a sin. It's not a failure. But sometimes it is essential to go back to the title and tighten it up in such a way that it actually matches with the final product of the thesis or the research project. And it happens when you're writing articles too. You start with an idea. It's kind of a generic one. Then you specify. Then you establish the structure, then you write, and then you never write the introduction at the beginning. That's very important strategic information for you. When you write the conclusion, you go back to your title and you're like, you know what? That's not it. I wrote about this, so you change the title. So these are possible, but it's all within a ballpark figure, so to speak. It's within a range, unless you're really changing your dissertation topic, which I hope you don't do, but sometimes it happens. The next thing is, and this is very, very important, but also extremely difficult, almost torturous, to write down in one paragraph why you're writing that thesis, what you're writing about, and what do you think your findings might be. I have a question here. It isn't to bring out in writing the type of audience we're writing for or how we have handled that audience. Some departments encourage that. This is discussed, Alfred, in the methodology section, and it gives a background of why you're engaged in this issue. Do you have any vested interest? Do you have experience? So, for instance, also the whole law school where I work and then also studied, we encourage that, but some law schools don't do that. However, at the publication stage, especially if your thesis becomes a book or an article, you're more than welcome to identify the audience and also identify the reasons why you're engaged in this work. It's part of academic honesty, but it's also politically very salient sometimes that one does that. So, for instance, for many decades, I did human rights law work, and I'm very clear about my engagement with that kind of work. It's not an academic pastime for me. It's not something that is a theoretical question. It is very important to my personal life and personal history and societal engagement as well. And so I do make it clear. It doesn't mean I'm invested in this and I really will work for that. It means I've seen enough, worked with enough many people, and I've been in the midst of this enough to know or to believe that this is a very important topic. And then I give the reasons. Again, one of the pitfalls of sometimes when we have been through so much and when we've seen so much, we emerge out of that framework as righteous, and rightfully so. I mean, if you've seen so much violence, or if you've seen so much illegality and brutality and corruption, you would have a reason to say, no, I don't want it to be this way. But righteousness never translates well enough into academic work. It's just the beginning of the sentence. It's a belief statement, and the larger public often does not share your belief. And so the onus falls on you to convince them that you know it's important, or you believe it's important, but these are the reasons why they also should think that it's important. So it's really important to position yourself, even though you know what you're writing and what you're working on is very, very important. You know that in the heart of your hearts, and your community knows that. But remember, if it was so important for the larger society, it wouldn't have become a problem in the first place. People would have seen it that way, and they would have taken care of the problem. So that means there's what's called a counter public. There's always going to be people who are going to question your knowledge, your wisdom, your presentation, and I'm going to get to that in a minute. But this is something that you should always prepare yourself for. That people are not going to agree with you, even if you have your, SJD from Oxford. It's just an example of, the highbrow universities, or Oxbridge in England, or the Harvard, the Harvards, and then the MITs, and then or in Canada they have their equivalents. Even if you get those degrees from these institutions, it doesn't mean that the public is going to listen to you. It's just you're going to have a little institutional backing. Because these are elite institutions, and then they create global elites, and those global elites almost always come with a lot of money, and they have a certain clout that comes with their class position. So it's not that what they create is more veritable, or it's like the only new word that will come out of these institutions. It's just that they come with social position, and they come with political position as well. But even in those cases, there's no guarantee that what you've written will become a new public truth. It will always be contested. Okay, so the going back to this one paragraph thing, you can play with it yourself, both at the LLM and at the SJD level. Write a paragraph, put it in front of you, look at it. Let somebody else look at it. See whether they understand why you're writing this work, and from what vantage point, and to what end, and to what audience. And can you do all that in one single paragraph, whereby sentences don't run 3 lines, which is another important aspect of it. I don't know what happens to people, but when they start writing academic work at the graduate level, their sentences get longer and longer and longer. If you cannot read a sentence in one breath, then you have to break that sentence into smaller pieces. I mean, it's just like a standard rule of thumb. You cannot write very, very long sentences and expect to keep your audience with you. You have to show mercy to your reader, be an advocate for your reader. Remember, writing is a form of communication, very powerful form of communication, and it's a vocation. You are not the king of the universe, and you cannot expect everyone to understand what they read just because you think so. And I'm saying it as a senior scholar. There is no guarantee that at this stage and age, I write something and I write in a muddled way, and I'm just going to say, well, they have to understand it. No such thing. It is an engagement. It's a form of reaching out, and you are the one who's reaching out. And therefore, the responsibility lies with you to be as clear as possible. So, in terms of structure argument, this is kind of difficult to discuss because I haven't seen your proposals, or maybe you don't have your proposals yet. But there are three basic structures whereby you establish a large piece academic work. Okay, and they actually correspond. I mean, this is my invention, but it worked quite well over the years. They correspond to three geometrical shapes. There's more, but the three basic ones is the first one is a triangle. That's the normal, the pointer side up, and this kind of structuring of argumentation means you start from a vignette or from a legal occurrence or an event, and then you establish a context within which you interpret what's happening. So the base gets larger and larger. Your thesis grows from an entry point into a much larger context, much larger literature. So in effect, what you're saying is what I'm seeing fits into the pattern of this larger framework. And it can really be contextualized and understood in this larger framework. So then the question is, what's the contribution of work like that? Well, the contribution of work like that is often related to the fact that you might be looking at something that people didn't look at before in that context. So that's your contribution. You're saying, look, this one particular phenomenon or class of phenomena or this particular trajectory of development could actually be understood from this wider perspective. So it's not a singular thing. And when we put it in this wider perspective, we can also see its implications, its larger impact. We can read it in terms of its social and legal meaning. So providing context allows us to know more and better about this particular phenomenon. The other structure that is quite common is the upside down triangle. It's not like a triangle, I can't do it, but anyhow, it's this. And that's a very interesting one because you start with a larger framework, and this often starts with like an extensive literature view on the subject or legal summaries of what has been happening. So you create what we call a panorama, all right? So you tell us, these people did this work on this area, in this area, these people did this kind of engagement, these are the theories, these are the publications, this field is very important, and then you narrow it down. So you narrow it down for two reasons, either because of all the things that you present at the beginning of that panorama. One or two things for you are very, very important, and you want your audience and your reader to pay attention to those. And therefore you say, of all these things, I want you to look at these ones because they are really essential, really important. Or you have a question and you're coming up with something that you think will not be working in that framework. And you're like, they've said all this, I've read all this, but there's this other thing that's happening. I cannot explain it in this context. It's causing a problem. Maybe it should take us to question some of our truth values. Maybe there has to be changes in the legal framework. It doesn't have to be just debate. I mean, it could be a certain very adverse impact and influence of legal arrangements. And then you could say, let's say foreign investment engagement of companies in extractive industries. And the legal framework always emphasizes the benefits, both national and international. But let's say you're coming up with a very grave understanding of environmental and societal impact of these foreign investment strategies with a lack of environmental law to protect the public. And so you're saying, okay, this is the framework within which these foreign investments are regulated. That's how they come in. That's how they operate. But there's also this other aspect of long-term implications for the public, which is not included in this legal framework. And I want you to look at this one while you're discussing this larger panorama. Does that make sense? I want to see the comments. Are there any questions thus far? I don't like our students being so quiet. So to recapitulate, these are structures of argumentation of larger work. The 10-point up triangle and upside down, and then the last one is at least what I would like to discuss for now is the hourglass. Okay, and most dissertations that want to say something new follow the hourglass figure in argument structuration. So if you remember the hourglass, it starts broad, it narrows down, and then it opens up again. All right. So the hourglass indicates that you start with a general determination of the field and the legal framework and the legislature. That's the beginning. So let's say state A. And then with the hourglass, you narrow it down to the phenomena or the development or the particular legal piece that you're examining. And then you come up again, and then that's state B. That basically is the operation whereby you say, thus far, people discussed this particular approach or this particular development from this perspective. Now I'm going to look at this event or this application, and I'm going to analyze it. And then as I come out, you're saying, well, looking at what I just examined, I think we should add to our perspective, or I think we should change our perspective. And the difference between, the upside down triangle and the hourglass is that with the hourglass, you're actually making a direct intervention to the existing literature, showcasing where things should be changed. And that's the hardest work, the kind of SJD. It's difficult to do that at the LLM level because it really does require great expertise and knowledge of the field. But often the hourglass kind of structuring, those kinds of dissertations become books, and they become public knowledge, and they become circulated, and sometimes they become, so to speak, path-changing interventions to academic and political knowledge. Sometimes as the hourglass figure narrows down and opens up again, state A and state B of state of knowledge, state B can include policy dimensions and recommendations, which again makes it quite usable by the larger public. I'm not suggesting that's the only way to go, but that kind of dissertation often has a much greater circulation once it's defended. So, bibliographies. Often people think that's the least of your worries, and I would caution you otherwise. Bibliographies are a bit like, your friends and relations in life that will follow you and your reputation. Your academic work is, at least in part, judged by the references that you established yourself and the literature that you based your argument on. So one thing is for sure, like historians, legal scholars tend to sometimes make the mistake that if you follow enough of the case law, and then if you have enough legal references, that's 2/3, if not more, of your bibliography. Wrong, because you don't need to do that in a PhD SGD program. You can do it on your own. Just write a report. Just work as a court clerk. Articles with some judge, and then do the same work. That's not the idea of being at the university, at a law school, doing a graduate work in legal scholarship. So your bibliography is almost like your identity card. One of the things that I strongly encourage people to do is when you're reading an academic article, always go to the bibliography and examine the works that the author relies upon. Not just the documents, but also the works. That will also give you a clue about this previous point, the theoretical background. What vantage point they have, what perspective they come from. Are they using a critical engagement, or are they endorsing something existing, or are they producing ideas that lead to change? All of these you can actually decipher from one's bibliography. So if a barren bibliography is there, and if the barren bibliography is your work, it means problem. It just means a law report. It doesn't mean scholarly work. It certainly doesn't mean contribution on its own. So how do you establish this bibliography that is rich and that is actually reflective of your thinking processes and your training? We often encourage our students, graduate students, to have 3 bibliographies, all right? And I've done my work this way, and I train my graduate students this way as well. There's bibliography A, B, and C. So within A, you should have, maybe 10, maybe 20 works that are legal scholarship, not legal documents, legal scholarship that you cannot live without. Some people even include literature. If there's an account of a war, let's say you're writing on war crimes, and there's like a very moving account, literary account of war that really embodies many of your concerns. I know it's unusual, but it is okay sometimes to have these things in your bibliography. Or in this day and age, I encourage my students to include documentaries or footage or testimonies. These could also be in your bibliography, but your bibliography, think of it this way. If you are to stay in academia and continue your work, your bibliography will form the foundation of the courses that you will mount and teach. All right? So you want to make sure that you choose your friends, so to speak, in this case being books and articles and written work, very carefully. That's your bibliography A. And you want to make sure that throughout your thesis, we see glimpses of these works and the insight that they bring in conceptual terms. And I mean, there are methods of approaching, these major works in your bibliography A, but one of the things is creating what's called a conceptual glossary. So writing down the concepts and key debates that are of essential value to you, and then keeping them in front of you, which will then inform your thesis writing process. I have a question here from Brutus, and they suggest the quality of a legal issue will determine in large part how well one paper is written. Many problems students encounter result from not poor writing skills rather than weak analysis. Exactly. That's exactly what I'm saying. That's why, in order to avoid weak analysis, and I'm not talking about writing skills. Thus far, I haven't talked about writing skills at all, other than suggesting don't write long sentences. This is about structuring an argument. And the triangle, upside down, and then the spiral are all about structuring an argument. They are not about writing skills. Look, if you have money, you can hire a very skilled editor, and then they'll just kind of wrap up your poor writing skills. That's not the issue. If you don't have the argument and the substance, no one can make that baby live, right? So in that sense, bibliography A, going back to Brutus's question, is part of what it takes. You need to identify whose works inspire you and why, and what's the perspective you're coming from, and again, why. What's the value added in terms of you presenting this debate, and for whom? That's another very big question. Are you talking from the perspective of international finance? Are you talking from the perspective of subaltern classes? Are you talking about labor law from the position of, the employee or the employer or the public in general? Where are you? You could talk about the same issue from all 3 perspectives, but that will just be a summary then, because you need to identify how it affects different constituencies, so to speak, and you should care. You can't just summarize. You should care, and you should look into implications, especially long-term implications of what you're doing. So bibliography B then is about the legal documents and anything that constitutes the subject matter of what you're writing. And perhaps rightfully, most of our students are very anxious about their bibliography B. But let me tell you, unless you have a set bibliography A, which is also the basis of qualifying exams in many universities and institutions, you're going to be all over the place about bibliography B and collecting the materials that you collect because you won't have criteria. The sky is the limit. You can go on and on and on, and there's going to be more and more coming, and then you won't know where to end it. You won't know why. And so one of the things you can do with legal documents and necessary doctrinal basis of the thesis is put subheadings, and not just topics, but perhaps concepts, perhaps approaches. So you can say, let me just look at the list of dissertations again. I'm just going to improvise, and forgive me if I'm making any mistakes in terms of understanding your thesis topic. So Etini, the topic is artificial intelligence, criminal law, and justice. This is a topic area. It's not a dissertation title. It's too generic because I won't know what it is. Is she for criminal justice? Is she for incrimination investigation of artificial intelligence? Is she after ethics of artificial intelligence? I have no clue. And I'm not suggesting this is wrong, but it's just the beginning. But either way, I picked up her title because she can have documents on artificial intelligence and law. She can have documents, legal documents on criminal law and artificial intelligence. And she can have documents on, I'm sorry, there's construction outside, just 1 minute. Okay, sorry about that. This is the benefits of Zoom, or rather online teaching. And then she can have documents about what she means by justice, how she defines justice, theories of justice, legal theories of justice, justice and ethics, the relationship between artificial intelligence, everyday, and justice. And those will constitute separate clusters in your bibliography. Rather than putting everything together in a huge pile of legal documents on artificial intelligence, which would make it very difficult to work with. You see, it's a bit like, how shall we say, climbing a mountain that is very high and that is difficult. It doesn't mean you can't climb it, but you certainly can't climb it in one go, in a crazy run. You have to camp at stations, and then you have to measure altitude, and you have to take precautions, and then you have to determine the trail. And if that trail proves to be very difficult, then you have to change and find another trail. You have to determine route 3, route 4, and you should always consider the fact that the worst thing that can happen to you is to be lost, and to freeze or to fall. And so I'm not trying to scare our students, but writing graduate work is very similar. There's a summit, which is a submission of strong work, but you can't get there through shortcuts. You have to prepare at every stage, and you have to make sure you never get lost. You always have a roadmap. And then these bibliographies A, B, C actually help you to establish that roadmap. The bibliography A establishes the conceptual groundwork. Bibliography B, under different headings, establishes the documents that you'll be covering. And it's not going to be a mishmash, but it's going to be clearly identified. The trail will be clear. And bibliography C is what we call secondary literature. So academic works that are on artificial intelligence, all right? People who wrote on it. People who wrote on criminal law and artificial intelligence. I'm just going back to Etini's LLM topic. So like there are different variations of it depending on the topic itself, right? So you want the companionship of people who wrote on it from a scholarly perspective. Sometimes, let's say EU Commission reports, or sometimes reports that are provided by NGOs also fall into that category, where people discuss the same issue. So what would be the biggest danger for bibliography C? Can you guess? So you identified core theoretical literature about how you look at law, how you look at criminal law, legal theory literature. That's bibliography A. Then you identified your documents, bibliography B. Then you came to Bibliography C and you're doing lead searches and looking for people who wrote on a similar topic. What would be the worst news as far as you're concerned? I'm just going to see if anyone can answer that. Okay, the worst news is, and we see it, I would say 90% out of 100%, especially among our SJD students, they come to you and they say, someone just wrote what I wanted to write, right? They come up with a title and an author who worked exactly on the same subject. And my standard response is the pie is big enough to be shared by many. The title might be similar. Did you read the work? And I just got a note concerning legal philosophy methodology, any basics. But for that, I need to teach a workshop. I don't think I can just do it on the go. And then I'm not sure. Your department, your law school might have a legal theory, legal methodology course, and if not, this is something we can discuss for the summer or for later on. But this is not something you can just take care of, like, in one go. This requires training, and that's part of the reason why certain law schools stand out, because they really make a contribution, whereas others produce theses that basically are doctrinal, and then they just repeat the legislation, and they're lost. I mean, they hardly get published. They don't have circulation, and they add up onto the pile of expert knowledge, but they don't necessarily influence the public. But anyhow, so I'm going to go back to my thing about Bibliography C, and then this is secondary works working in the same area, and then you came across a title that you think, oh my God, this is what I wanted to write on. It's already done. I should change my topic. There's already expertise. No, there isn't. There's 100 ways to look at the same thing. And without really reading it carefully, you cannot determine whether the person did what you wanted to do. And suppose in the worst case scenario they did. Then that's wonderful, because that means all roads lead to Baghdad. What you've chosen is an important topic, and then there's understanding emerging on this topic. So what do you do then? Well, you can continue from there onwards, and you can use that person's work in full citation as a precursor to what you're going to write on. That is no reason to change fields. In fact, the more you find things that are relevant to what you're writing, the more you should cherish. Because that means that's an emerging field. That means that's something that people are communally, internationally thinking about. And you're joining a conversation. And then that's really, really important to keep in mind. This is not your personal achievement, as much as it is in terms of writing and coming up with new ideas. Academic work, scholarship means you are joining traditions of conversations. And you need to identify these conversations. You're not out on a fact-finding mission. You're not a detective, or you're not this genius artist who is going to do, even in that field, history of art clearly reveals to us that there are traditions. These are streams that emerge, and you're one of the participants. And so in so many ways, one should be humble. As much as having a distinct voice, one should also be humble in one's engagements with traditions of thought, because you're joining something that started before you. And the responsibilities on your shoulders for it to continue and to flourish and to take it to new places. But most likely you're not ever going to be the first one to say it. There are going to be other people thinking similar things and looking at similar things, because let's face it, law is a social phenomenon, and legal interpretation is determined by historical and political events. Since you're not the only one living in this society or in this globe, likely there are other people who see similar problems or similar issues, and that's a good thing. It's not a bad thing. So looking for false uniqueness is a danger. One should be humble, and one should think if there are similar works that one finds in one's field, and take courage and strength from these kinds of works. Are there any questions about what I've just said? Because it's a very, very common occurrence. And students often try to change their dissertation topics, and then the responsibility lies with the supervisor to explain that there's still so much to be said in that field. And then go back and read what you found carefully and see whether you can take it further. So, what are some of the common pitfalls? Well, it depends on, and remember the analogy of climbing a mountain. You can't do a stint and a jolt and get to the summit. It has to be stages, and it has to be carefully planned, and there has to be a roadmap, and you really need to know your trails well. Continuing with the same analogy, one of the most common mistakes once we establish the bibliography and the thesis statement is what we do at the stage of thesis proposal writing. So different institutions have different mechanisms in terms of examining thesis proposals and approving them. Some institutions rely on the supervisor's wisdom and or the supervisory committee's wisdom, and head of the graduate program or the head of the law school does not have much say. Other programs actually have a superior body that examines all dissertation proposals. Some other universities have faculty of graduate studies whereby the proposals are vetted, not just for formal reasons, not just to make sure you've got the right format and you've got enough number of pieces in your bibliography, but in terms of the substance, whether the argument holds. So one of the biggest mistakes that anyone can make when writing a proposal is to suggest that this thesis will prove such and such. This thesis it's not argues, but this thesis is based on the findings that. How could you have findings before you write it? How could you prove something before you did the work? So there's like a cluster of words you should avoid like plague when you're writing your proposal, because remember, you're imagining a thesis. You haven't written it yet. You cannot know what your conclusions will be. You can project where your contributions will be into the field that you've chosen. But those have to be fairly generic, because if they are specific, then it's not a proposal. You have to propose the work that you will do. You cannot propose your findings. I hope this is very clear. And so the way you structure a proposal is, first of all, there has to be continuity between chapters. There has to be a flow. And I often give the analogy of writing a novel. And you might think, what's the relevance? Well, the relevance is this. It's a major piece of work which can extend from 150 pages to 400 pages. And practically, it is like fiction. It's a very extensive piece of work. I'm not talking about LLMs, but more or less same principles apply there as well. So let's say in a novel, in the first chapter, you're introduced to a character, which is very lively, and a scene, a background. And you're really taken by it. And then you go to chapter 2 and chapter 3 of your novel. You come to the end of the novel, there's no mention of that person or that background. What kind of writing is that? It wouldn't pass the muster of any editor for publication, because you would have lost the opening. You would have lost what we call the leitmotif. So one of the, again, most common mistakes in terms of proposal writing, but also in terms of thesis writing, is that you can make big grand gestures and claims saying, I'm going to do this, I'm going to do that, and I'm going to do the other. And then you look at the chapter summaries, and the chapter summaries don't match with what you claimed at the beginning. And then your reader goes like, how does that work? Like you made all these claims, then you have to exhibit them in your chapters. And there has to be common themes running through the entire thesis. And in your conclusion, you should be referring back to the things that you claimed at the introduction. So you have to aim for what's called a cyclical structure, right? You have to start from one point and develop and develop and develop, and then you should come back to where you started and, let us re-examine what you claimed. I have a question here. It is desirable to include both sides of the findings, those that support research findings, as well as those that show contradictions of findings in the review of related literature. So I'm going to come to that. Thank you, Abraham. And it's a very, very important question indeed. And that is about the existential politics of scholarship, right? So, and I'm going to get to that once I finish the thesis proposal writing. So the last thing that is about thesis proposal is sometimes people provide 4, 5, 6 pages of explanation of why their topic is important, what legislation they're looking at, and then they come to chapter summaries, like very flimsy titles, no content in chapters. It's almost like a romantic who is proposing that they'll give their lover the world and the sun and the skies, but then they forgot to give the engagement ring, or they don't show up for their next appointment, right? You can't do that. If you promise so much, then you have to showcase it in your chapter structures as to how you're going to deliver what you promise. Or don't promise that much. Sometimes it's better not to promise too much in your thesis proposal, and scale it down a little, but do so much when you're writing. And remember, this is an exercise in imagining. You're basically creating a model of what you're going to be writing. You're not writing the actual thing. And the model, just like in architecture, should be to scale. I mean, if you come up with like this outrageous flamboyant maquette model in School of Architecture, your teacher would say, why don't you go to School of Art? You're going to build this stuff. People are going to live in it. They're going to use it. So you got to make sure the material matches, the measurements are accurate, even in your model. So it's exact same a calculation for your thesis proposal. Your thesis proposal is the model of an imagined thesis. It cannot promise the world and not deliver. It cannot state findings that you haven't actually looked at. It cannot claim conclusions that you cannot arrive before you're doing the work. But it can identify the targeted audience, the planned contribution, the stages of the research, the methodology, and tentative chapter headings, including some content as to what might be going in there. The beauty of that is, once you write your thesis proposal, well, first of all, you become something called ABD. That is short for anything but dissertation, but it's actually, there's a larger Latin version of that. But that means you are over the worst. You've finished your coursework. You've given your qualifying exams. I'm talking about SJDs, not LLM. And you have now an identified thesis proposal that is approved by your whole committee and faculty of graduate studies. So Omar says, don't you think the LLM stage, it's enough only to highlight the problem rather than giving suggestions for problem solutions? Exactly. That's why I'm underlining the fact that what I'm talking about, this larger thesis proposal, is for the SJD. And maybe I should be more careful, because the majority of you here today are LLM students. And so let me paraphrase this then. For the LLM, the expectation is not to find original solutions or to make an original contribution. For the LLM, the expectation, that's a universal expectation, is to showcase expertise and to produce learned work that could be reliable upon as source information, right? So for the LLM, the bar is much lower, and that's okay, because after all, it's the first degree in graduate studies. For the SJD, the bar is much higher. So indeed, for the LLM, if you identify your field of study, if you identify the problem that you're attending clearly, the theoretical framework, the methodology, that's often enough. You don't need to go any further than that. Some LLMs engage with policy-relevant findings. Some LLMs have applicability in the legal field as source material. but often they take longer to write. So they are more akin to a report, and a learned report with detailed background and analysis. So for those who write their LLMs, their job is obviously much easier, and then they're given a much shorter time frame. They have to take less number of courses. Does that mean it doesn't carry cloud? Of course it does. You're still specializing, and you're still going one step further in your education in terms of expertise. You're no longer just any other law student or a freshly articled lawyer, but you're someone who studied in depth clearly a particular field, and you also showcased and you got approval from experts that you can write on it. Whereas for the SJP, it is the acceptance to legal scholarship. And you really need to prove yourself in terms of your original contribution, your ability to master a subject above and beyond learned understanding of it, critical analysis, comparative skills. All of these come with SJP, right? So in terms of what you do concerning what to do after the thesis proposal is accepted, or for the LLM, again, like the proposal itself, I believe should be approved by your supervisor and your committees. I'm not privy to how the LLMs are administered at Nergis Faculty of Law, whether it's one person, two people panel, oral defense. I don't know these, but either way, we're going to jump to the writing stage. And I had a question here from, I believe, Abraham. And it's a very, very important question. So what is scholarship? Often scholarship is understood in a very traditional way of learning what is to be learned in that field and displaying that knowledge in a way that opens horizons, or that provides further insight to the public engaged. So there's another question from Abraham. No, it's the same. Okay, all right. So what is not discussed about scholarship, it is one of the brutal fights that one would ever witness. It's a fight of ideas and worldviews and findings, and sometimes ideologies. And sometimes it's a fight against injustices. Sometimes it's a fight against the state. Sometimes it's a fight against certain groups. There's a reason why people engage in scholarship. No scholarship is quote unquote neutral. It could be balanced, and it should be. And it could be critical, and it should be. But there is always a certain kind of impact on the public from one angle as opposed to the other. You can do the entire framework and identify the actors and the interlocutors and the public. But in general, you yourself, unless you're omnipotent and occupy the position of God, cannot be neutral towards everybody. Every legal scholar has certain expectations from the legal system. Some of us wanted to work just, but how do we define just? How do we define justice? Justice for whom? Justice for Nigeria? Justice for France? Justice for Nigeria and justice for France could be entirely different things in terms of certain issues, including investment strategies. Look at the response to COVID. We all know that the nations that are included in G13 or G20 or even G30 already purchased all the vaccines and monopolized vaccine production. And so the rest of the world are either reliant on themselves, and countries like India produce their own, or they will basically face the pandemic with no protection. So pandemic justice, is there such a thing? Globally, the world is not a just place. Income distribution has not been just. Capitalism did not develop in a just manner. So when we talk about justice, there is no one justice. There are different kinds of justices. There are different approaches to justice. There are different approaches to law. There's some law that actually creates injustice. And so when you're talking about law that creates injustice, then you're talking about existing frame of law, and you have to imagine another frame of law. And then that's a form of critique. So what I'm trying to suggest is scholarship is not a neutral field. It's a playing field that can be very dangerous. And you will always, always be challenged. And your first and foremost task should be able to defend your position from a learned standpoint, with facts and findings and other debates that support your approach to the issue. You are engaging, in so many words, every time you publish something in a form of action. And that's why, for instance, in authoritarian regimes, often law schools are the first ones to be closed, or lawyers are the first ones to be put behind bars. And legal scholarship is the first kind of scholarship that's banned, especially if it's taking a position against the state, because it's a very powerful sword. The pen is a very powerful sword. But that also means you're going to make enemies. That also means, going back to Abraham's question, every time you include certain findings that support your argumentation, there's going to be a whole other literature which will be arguing otherwise. So you have two options: either turn a blind eye and presume it's not there, or even be more ignorant and say it's not valid, it shouldn't be even taken into consideration. And the third option is, exactly as Abraham is suggesting, put them into your work, not to the main body, but to that other world in the text, which is known as the world of footnotes. All right? Footnotes are your best friend when you're writing a treatise, legal or otherwise, because that's the place where you can provide commentary. That's the place where you can actually show to your audience that, look, I've argued this, and these are the references I used. But then there's this entire other debate where people look at the same issue from an entirely different angle. And this is what they suggest. And that's why I disagree. This is where you can speak your mind, and that also induces trust, because it means you're not following a blindfold. You're not just looking into what you chose to look, but you looked around and you saw and you read and you paid attention to opposing points of view and you acknowledge them. But you also tell your reader why you are not following those opinions, but this one. You give the reasoning. And that's a very essential part of scholarship. A different version of that plays out in your defenses. So now I'm going to speak to our LLM students in particular. In the defense, what's the defense? You're defending yourself. Who are you defending yourself to? Your jury, your supervisory committee. So in effect, it's a friendly crowd. The world out there is much less friendly. So please keep in mind that just the fact that you got a degree and then you wrote a thesis does not mean that the world out there will agree with what you've written. You're going to be questioned about it again and again. But at least the idea is that through academic work, you're going to learn the skills of how to substantiate the arguments that you build and how to establish your stance, right? So in that sense, in your LLM defense, if it's an oral defense, you're going to be asked questions. And I've encountered in more than one case, the students are very taken aback. Like, they're like, why are you asking me this? I wrote it with you. Well, the whole point is you should be able to articulate what you learned in your own language in the presence of another person. And that's why in a defense or a jury, it's not just your supervisor, but second committee member, sometimes a third. In an SJD, you've got your supervisor, two members of the committee, the dean's rep, the external, the internal, external. They're like all of a sudden 6 or 7 people, and you've only known 3. And all 7 will be asking questions, and you'll be like, what is going on here? Why am I being cross-examined? Well, that's the whole idea of an academic defense. You should be able to respond to these questions in a learned, structured fashion. And that's when you earn the title of a doctor. That's when you are academically acknowledged as a peer, not just by writing something, but being able to explain and to stand under crossfire with all your, composure and in terms of responding fully to the questions. So, what's the biggest mistake you can do in your defense? Take umbrage, take insult. Don't ever. The whole process itself is geared towards you defending yourself, but not in a defensive way, in a learned way. You have to explain what you've written. You have to explain your ideas. You have to explain your resources. And you'll be faced with more questions when you explain. And you're always, always welcome to ask questions to the person who is questioning you. Did you mean this? I've argued this. What's your opinion on that? Because the gist of it is these defenses are meant to be dialogues. They're meant to be exchanges and communications that actually build upon expertise of a select community. And one of the things that we say in terms of PhD defenses or SJD defenses that it's a lucky moment where 7 experts read everything you have written line by line. It's a rare moment in your life, even if you become, an established professor. It's going to be quite rare for someone to read what you've written with such care. So defenses are actually very unique moments of communication and dialogue, and you should take them as such. And sometimes you can have a hostile examiner. We have seen cases whereby the external examiner, although they write a good report, could be very hostile to the student, or it could be perceived as such. And they might bring forward questions from an alternative point of view. And then they might say, you wrote this and then you looked at it this way, but what about this other perspective? You haven't paid attention to it. So what do you do then? Any suggestions from the crowd? You're at the final stage, you're about to defend, there's this really respected external examiner, and your supervisor tells you everything is okay, they submitted their report, the thesis is defendable, and the examination starts, and all of a sudden the external says, it's all well and great, but you haven't looked at this and this and this. What do you do? Do you run out of the room? Do you say, that's it, I failed? Any suggestions? Okay, since I'm here to train you, one of the standard responses I encourage my students to give, because this does happen, is appreciating the viewpoint, never attacking another scholar, not just in your defense only, but throughout. Exactly. So Omar says you cannot include everything, but that may not be enough. Often you need to acknowledge the validity of the other viewpoint, but then give reasoning as to why you did not include it, and why the things that you included are superior in your mind. And that's why it's a defense. And you have to always think in a similar fashion when you're writing. You always have to be 2 people. I mean, the former Osgood Law School dean, Lawrence Sasson, when we did one of the introductory classes to the incoming students, he said the same thing, and I thought it's wonderful to hear it coming from an established legal scholar and a very respectable jurist and a dean. And he suggested you've got to be 2 people at one. While you're writing, while you're studying law, especially at the graduate level, it's you passionately arguing for something, and you have to be your worst critic. And you have to imagine what kind of question you'll be subjected to, what kind of opposition that could come to that idea. How could you be critiqued? So you have to presume that critique. You have to have forecasting abilities in terms of where you'll be attacked. And that's why, going back to the original question, you have to read different kinds of literature looking at the same question. Joachim said, could it be that Could it be how he understands it? But necessarily meaning I have to go back and rewrite the whole work. Look, if you were to rewrite the whole work and your supervisor will train you for this, you wouldn't be brought to defense. It would be irresponsible on behalf of your supervisor if the external was very negative to bring you to defense. So there are certain things that you may not know now, but in a good, decent, and professional supervisory relationship, your supervisor takes care of these issues. And if they tell you, no, this is not ready for defense, please listen to them. And if they tell you, I've got the report from the external, we are ready for defense, you should go into that defense with that knowledge, no matter what the external says. If the external is critiquing your work, they will often suggest that they're only doing so because the work is so good, but they're trying to prepare it for publication. It's not because they want you to rewrite. Because if they wanted you to rewrite it, you wouldn't go through the defense. And in all situations whereby the thesis proceeds to a defense and there's a horrendous fight, either among committee members or the external ends up being too critical, that's not how this profession should be run. And we often have difficulties with the supervisory committee and the student gets really hurt. Unless the student insisted that they can't do any more corrections, they can't do any more work, they pestered the supervisor to go for a defense, and the supervisor said to them, there are problems with the thesis, I am warning you, right? And if that happens and the external really critiques and the committee is not really favorable to the thesis, then the student has been forewarned. But under normal circumstances, your supervisor will tell you when it's ready for defense, and you should go into the defense with that psychology. Any question that is coming to you is not for you to rewrite, but for you to add finesse, or when it's ready for publication, to include that aspect as well. It's a very friendly critique, very constructive critique. It's the same for LLM. Unless you're ready, your supervisor would not and should not call for a normal defense. The work should be entirely ready. And sometimes the students get very annoyed and very angry because they want to finish it. They want to go on with their life. They're paying fees. It doesn't feel right. It's taking too long. But the downside is, if your supervisor says, look, this is not ready, and in front of an external and sometimes a member of the Faculty of Graduate Studies, if you fail, that's it. You fail. You're back to the drawing board. You have to start rewriting all over again. It will take you probably another year, in addition to the fees and the embarrassment. So in that sense, the supervisory relationship is very, very important. So looking at the time, it's already been an hour and a half, and I'm going to slowly wrap up. And if you have any questions that I could answer right now, you can write them down. So I'm just going to talk a bit about the supervisory relationship. And I'm speaking here as a person, and this is by no means any critique of my colleagues here elsewhere, but I'm talking as someone who's been once a graduate student, actually twice. Actually 3 times. So you have to keep in mind that this is a human relationship. So you might really admire someone because of their work, or because they're the dean of a faculty, or because they have political clout, and you might decide, that's it, I'm going to work with this person, and I'm going to really, really show them that I'm worthy of their attention, and you're determined. And these are all noble causes, there's no doubt about it. But it's a bit like, seeing someone from a distance and reading about them and hearing about them from the family and deciding, I'm going to marry this person. I'm going to spend my life with them and I'm going to have children with them. And, sometimes people do that. But it's not necessarily the surest of relationships in terms of a long-term commitment. So no matter how high you have an opinion of a supervisor, you really have to have this long conversation with them first. And you need to tell them what you want to write on and why. And if you're not honest in terms of what you want to write on, this is going to become a problem. If the supervisor tells you, I only work on these issues, just to work with them, if you start saying, oh yeah, and this is really of interest to me, and like craft an answer on the spot, in most cases you run into difficulties in the long run, because that may not be what you wanted to write on, and that might be just the supervisor's interest area. Remember, you're going to invest 5 to 7 years of your life into this project, and your thesis remains with you. It's part of your reputation wherever you go, because it's published work, and right now it's university accessible through databases, and sometimes it will become articles and books. It follows you, and it's part of your personality, it's part of your public recognition. And so it's really important to have a very trusting supervisory relationship. All right? And how will you determine that? You have to use your senses. You have to ask difficult questions. And you have to understand about their style of supervision. Some people, like myself, are very hands-on. I mean, I check on my students regularly. I hold extensive office hours. When the offices were open every Friday, the whole day was only allocated to my PhD students, and they knew that. And then they would come, and I would let my other students know that Fridays don't come to my office, because you'll end up waiting for hours, because this is for people who are writing their dissertations, right? Because that allows them the space for having conversations, in-depth discussions, tackling problems, methodology, and whatnot. And under COVID times, as much as I can, I'm trying to give that kind of extended space to my grad students, because this is an advisory relationship. This is mentorship. This is apprenticeship. It requires close attention. That's my view. Now, you might be a student who doesn't like that. You might be a student who has a lot of expertise. And you might be a student who doesn't want hands-on, in which case that kind of supervisor may not work for you, or you have to come clean with them saying, look, I really would like to write on my own time. I would like a flexi schedule. Would you be agreeable to that? And if the supervisor says yes, that's fine. But if they say, you know what, I don't feel comfortable with that, I work with timelines, I'm very methodical, then that's not the person for you. Or sometimes some people like supervisors who belong to a school of thought or established a school of thought. The given being, when you start working with them, they will expect you to follow their line of thinking. So you're going to produce work that extensively references their work, and perhaps you're going to join a group of graduate students who are all working on the same subject. Maybe this person has a grant which hires 5 PhD students working exactly on the same subject from the same angle, but you have to go in there knowingly, because in a situation like that, you can't wiggle your way out and independently determine your thesis topic. If you're coming with a funding package to study something specific, you cannot stay with that supervisor or with that program if you decide to change that topic. So you have to be very clear about what you're getting into. So I've got 2 questions here. Alfred asks me about, do I have any publications on what I'm discussing? I've got something that is on ethics of witnessing in legal scholarship. This is a free access website, and I'm working on a methods handbook for graduate students, but that's going to take a while, but hopefully not too long, in which case you can see some of these things that I'm discussing there. But the website, I'll let the Faculty of Law know when it's up and running. And then I have another question which says, in case where your supervisor tells you to write his or her way, what do you do in this case as a student? So we have to qualify, what does it mean, his or her way? Does it mean they want a certain structure in the dissertation? Does it mean they want you to use their own work and they want you to follow their own method? In which case, it's a black and white. Either you say yes and act as their protege, and that's the choice you make. That's not the only way to write a dissertation, but some people prefer to do it, or some structures only allow that, or you say no and change supervisors. I mean, I've done it myself. I started my first PhD and did my comms. And in the program that I was brought in, I later on learned that there was only a certain set of topics that I could write on. Then I left that PhD program. I'm not suggesting you do, and that was way back. And I started a new program, and I finished that, and I started another program, and I finished that as well. So like it wasn't, I didn't have a track record of leaving programs, but in this particular instance, despite the fact that I loved the institution, I had very generous funding package. I just saw that they wanted me to write on that specific topic from that certain angle, and I didn't want to do that. So it's, if it's a style business, if they want you to be more clear in your approach, or if they want you to use certain works, that is very negotiable. Of course, like they are your mentor, and you would be wise to listen to that. But if they dictate a topic on you, it depends on the terms of hiring and terms of engagement as a PhD student. If you're hired into a project, which clearly states this is a topic you're going to work on, then you have to follow or you have to leave. And if it's an open structure, an independent supervisory relationship, meaning you came to a part of the faculty and you approached them and you said, I really want to study environmental law from a critical perspective. And the student says, sure, let me see what you have in mind. And then you start sharing ideas and you start building a bibliography, and the supervisor will say, you know what, this is great, but I think you should look at that as well. These are all normal, and that's the way it should be. Because if you knew what you're going to do in the first case, you shouldn't be starting a PhD, right? So you have to accept a certain degree of mentorship. But the issue is, the question was, what if they ask me to write in a certain way? There it's black and white. Either you follow that scholarship and that project, and within limits, meaning you protect your independence as a scholar and you have your own ideas, you follow that project, or you decide, no, I'm sorry, I cannot work with you. And then, find another supervisor. And you might be surprised to find out how many changes can occur in a supervisory committee, sometimes in supervision, sometimes dissertation titles. It's not that unusual. I mean, it's not recommended, but it doesn't mean the end of the world. And you shouldn't fear for your life if you decide, you know what, this relationship is not working. I don't understand what they're saying. I don't want to do what they're asking me to do. And in that case, my advice is never finish anything abruptly, never personalize the issue, unless there's reason, like sexual misconduct and whatnot, and hopefully that's not ever going to be the case. But basically come to a clear understanding that you've changed perspective, and always inform your supervisor first. Don't go to the head of the program or the dean and complain about your supervisor. You know why? And I'm going to put this very bluntly. Students are the biggest asset of any faculty, especially in the graduate program. With one caveat, they don't run the programs. They come and they go. And the faculty establish that institution and provide the service in that institution. So making enemies among core faculty who are running the program and teaching in that institution is never a good practice. And besides, I mean, in general, making enemies in life is not a good practice. But if you are working in that institution, just because you change supervisors does not mean you're never going to meet this person again, and they're never going to be in any committee that looks at your work or funding. So it's very, very important to keep these things professional when communication breaks down, or when there is a reason to switch committees or supervision. So I have more questions. In some universities, graduate students are asked to look for a supervisor before they're accepted for studies. Another question, I think face-to-face contacts are important to have a general idea of who is the supervisor that their students will marry. I fully agree. So during the admissions process, in order to make sure that we can provide adequate service to our incoming students, it is pro forma to ask them in the application package who they think they can work with. And it benefits your application even more. And now I'm speaking to the LLM students who might wish to continue to SJB to get a written approval from that person. And I received many a letter as such around admissions time. You know, the person says, I'm so and so, this is my CV. If I come in, if I'm admitted, would you be willing to work with me? Does my project speak to your interests? And sometimes I say, I'm sorry, I don't have expertise. Sometimes I say, of course, I'll be honored to work with you. And sometimes I say, you know what, I think the best person would be so and so. Why don't you write to them? And you can state that correspondence in your application. So at least on paper, you come into the program with someone assigned to you, hypothetically. And that I'm going to underline. That is not a firm, confirmed relationship. That is a decision made by the admissions committee at the time of your file coming through. And exactly as Joachim says, you meet with this person, you have a conversation with them, and you decide, no, I can't work with them. I didn't understand what their work was. Or it could be the case that you may decide, I don't think I can personally work with them. Maybe they're too exacting. Maybe they're too laissez-faire. I mean, it is a personal relationship, and it has to be a personal relationship of trust. So you really need to trust your gut. If you feel very uncomfortable and scared in front of your supervisor, I mean, a degree of that is understandable because this is a power relationship, the power being built upon knowledge. And so a certain degree of being respectful is a necessity. But if you feel that your blood is curdling and you are kind of like holding your breath and you can't express your ideas, that's not a good relationship. And similarly, if you go in there and then at the back of your mind, you're thinking, I know more than this guy about the subject. That's not a good relationship either, because you might know more about this guy, but when you do your PhD and your external comes, you really need a strong supervisor that you can trust and respect. An easy supervisor, so to speak, does not equate to a good dissertation. You pay your dues later along the way. And I'm not suggesting, some colleagues are not able and others are able. But if you go and work with someone who doesn't have expertise in your field and you force them to taking you on because there's nobody else, then you can't expect them to give the kind of feedback that you need for good work. So it would actually be, you'll be guilty as charged. It wouldn't be necessarily their fault, because you would have been pushing them in that direction of, look, I really need to finish the dissertation. All you need to do is sign. Supervision is never all you need to do is sign. And when supervision is like that, that thesis is practically doomed, maybe not now, but certainly later. And there are also issues about academic honesty. I mean, we can go on a lengthy period of time, finding your own voice, not translating work without permission, making sure that either the supervisor or the student do not, quote unquote, steal each other's ideas. Sometimes I co-publish with my students, and there's a very set protocol about who did what and who's acknowledged for what. There are issues about publishing your work as you're writing your dissertation, and it's always very, very important. I'm just going to say a few things because it's almost going to be 2 hours, and I don't want to tire you too much. And we can continue some of these conversations in another venue. But other than your supervisor, rule of thumb, never send your work to outside sources unless it's in locked PDF format. Okay? And always make an acknowledgement at the top saying not to be cited without the permission of the author for work in progress. This is particularly essential for PhD students. And I'm not talking about the supervisor now, I'm talking about what's called predatory publishers, or journals that look like they are legitimate. But in effect, what happens is your paper might be rejected, but the reviewer who reads your paper takes the idea and builds on it and publishes it themselves. So you have to protect your work, especially in later stages when you're really making a contribution. And you should only publish the venues that have a track record. You should always send your work in PDF format. And in the very off occasion that you see your work cited verbatim or otherwise without any reference, then you are within your rights to contact the editor of that book or journal and present evidence that this is actually your work. Just because you're younger, just because you haven't published yet, does not mean that you don't have any rights. And you should protect your rights. And your supervisor should be working with you in those instances. But for those kinds of things not to happen, make sure that you don't openly circulate your work in blog format. Make sure when you send it to journals, it's always in PDF format. And make sure when the reviewers reject your work, you have very clear understanding of why the rejection was, and you're within your rights to ask for a full report. And I mean, not now, but maybe another time we can hold a workshop. And I did that when I was at your university, at Nergis University last year, how to publish, and why to publish, and where to publish. We can't do it right now, but just remember what I said. Always send it as PDFs. You have the right to ask for full review reports. And if you find that your work has been used extensively without acknowledgement, you are within your rights, with proof, of course, to apply to the editor or the press or the journal, starting an inquiry. Any questions about these? Okay, so the last thing I'm going to talk about, either for LLM or PhD, SJD, what do you do with your finished work? There are two options. Some programs discourage students from publishing their chapters as they write the dissertation. In the programs that I work, on the contrary, we encourage them to publish them. In effect, there's a formula that if you published 3 or 4 acknowledged pieces in known journals, sometimes it is possible for those to be accepted in your dissertation. Some programs don't have that option. But in general, it's advisable that you don't wait for publishing until you finish your PhD, for several reasons. One is, if you're going to stay in academia, it is a fact of life now that globally, universities are using contract labor. What that means is full-time academic jobs are diminishing in number. And instead, most of these institutions, up to 50-60% of their personnel are relying on contract faculty. And it's applicable in Cyprus as well. And it's not a good direction for the well-being and longevity of the institution. You do need the core members of the staff, and education is the third sector now internationally. So there's no deficit of students. So it's a bit of a conundrum as to why this contractual work model is taking predominance and creating another form of precarious labor. But that's a separate debate. So how does this affect you? Likely when you finish your SJD, PhD, and if you want to teach at a university, there's going to be insanely tumultuous and unfair competition. There's going to be one job for which 200 people apply. Under normal circumstances, at least half of them would have qualified for that job, but there's only going to be one position. So most people in the teaching profession for 2 to 5 years will move from postdoc to postdoc, contractual teaching to contractual teaching. Sometimes it can extend itself to further. And in order to be recognized in that huge pool of applications, if you're going to stay in the university, you have to make a name for yourself as an academic, which comes through publishing your findings and creating a reputation for yourself as a thinker and writer. So that's an important incentive to publish. If you don't want to go into educational sector, and I mean, my understanding is that with an SJD, there are so many potential openings for you in government, in international non-governmentals, local non-governmentals, bureaucracy, public service. There are many, many options with a higher degree, especially in an LLM. In that case, it really helps if you showcase your writing and analytical skills in the form of a refereed publication, whereby you can then proceed to suggest that it's not just the academic institution, but also the outside world that acknowledges your work as a thinker, as a writer, as a policymaker, as a reputable intervener in key issues. So the question is, where do you publish? Do you always have to publish in academic journals? Not necessarily. You can publish gray papers, yellow papers, working papers. You can apply to a government department if your work relates to what they're doing and if they're agreeable to the critical stance we bring. You can publish a report. You can publish reports and working papers for international organizations. So please do not think that law journals or related journals are your only venue for the public to hear your voice. Be versatile in publishing venues and always avoid predator publishers. The ones that make you pay a fee, the ones that return your reviewed material in a week or 2 weeks, those are predator publishers. And does that mean they're not read? Well, they're read, but they're not respected. And people often consider publishing with those kind of publishers as an act of last resort. And it actually shadows your reputation rather than adding to your reputation. And as I said, this will take an entire different discussion. How to choose a journal, how to prepare a chapter for publication, how to prepare a dissertation for a book. If you desire to have discussions on these, you can contact the head of your faculty and your graduate program director and your dean, and I'll be happy to guide you further. But yeah, I think this is kind of what I wanted to cover at the moment in terms of how to make your graduate studies dream a reality that fits you and that is beneficial to you and the larger public at the same time, and that is not a torturous 2 or 5 or 7 year journey where you seem to think you're only responding to an institution or your supervisor. You're not doing this for that. You're actually becoming a very valued member of the society, a very valued member of the learned community, whose opinion should add new perspectives and insights to the public opinion. And that would be owed to your efforts and study at the graduate level. So this is not just a career move. This is not just a degree, but this kind of education also comes with a very important public responsibility. Thank you. Oh, and I wanted to share slides at the beginning, but my whole presentation took longer than I thought. I've got a whole set of slides, about 20 of them, on ethics of witnessing. Those who are interested in, there is a site I can lead them to, forward them to, where they can actually look at these slides. This is about methods and how you approach scholarly literature and how you determine your position and how you embrace the responsibility in terms of scholarly production.
Hello again. I think I'm on the stage. Yeah. And thank you very much, Professor. It was our pleasure and honor to host you. I think your presentation and the conference was fascinating, and our postgraduate and PhD students will definitely observe new information regarding the thesis procedure. And I think we will have the continue about the second or third conferences with you, and hopefully. And regarding the Sarkar Jalil point regarding legal philosophy methodology, and also one of my colleagues sent me a message. First of all, she congratulated you about for your conference, and also she pointed that we can make another conference regarding critical approaches to legal studies or legal philosophy in this regard. And probably we will do it on Meet Google, so it will be much more interactive with the students, particularly to those who are writing their thesis at the moment. As you pointed out, most of the students right now, they are at the very early stage of their thesis. So the headings that I sent you are just the topics, and they didn't even write the thesis proposal to their supervisor. So most of them are going to change as a title, but of course they are the main idea. Thank you very much for today, and hope to see you again in the next workshop.
Thank you. It was great pleasure, and I hope it's been of benefit to our students. And as we discussed in person, this is a continuation. This sort of training is a very essential part of graduate education, and law schools who engage with this kind of mentorship produce beautiful, really substantive, long-standing work, rather than just, a pro forma, a standard dissertations. So I really appreciate this opportunity, and I hope this has been beneficial to our students.
Thank you very much.
I'll catch you at bus.